Good afternoon. I'm Suparna Malempati, and I'm from Atlanta's John Marshall Law School. I teach legal writing, trial advocacy, and criminal procedure. And the funny thing is, I go to advocacy conferences, and I talk about writing, and I come to writing conferences, and I talk about advocacy. So I wanted to start today, I'm going to talk to you about advocacy and how it's going to help to teach our students better analytical skills. But I wanted to start with a premise. Over Thanksgiving break, I pulled out an old DVD that I watched with my son, and this line just stuck with me. You know, the Karate Kid 2, I don't know if you've seen that. I love Mr. Han. I may be saying something about my age, but he was so endearing in that movie. But he said, you know, there are no bad students, only bad teachers. And well, I know a lot of us are thinking, well, no, I kind of know some bad students. But the point is that as teachers, we have to adapt to changing times. And we have to try to figure out what's going to work in our classrooms and how to effectively impart information and how to effectively engage our students. And we have to consistently adapt and change. We cannot be adverse to change. So let's talk about who our students are today. And we've heard some of it in the presentations earlier. This is my outline. We're going to talk about the challenges of the modern day student, the advantage of world communication in our classrooms, and I'm going to give you some suggestions for classroom exercises. So this is an example of the current college classroom, right? Laptops everywhere, and they are looking at their computer screens. Now this could be law school or business school as well. It's not just limited to college classrooms everywhere. And as you see, students, no matter their ages now, but students are focused on the screen in front of them. And they are not looking at the teacher as they used to. Right? That's how when I went, you know, everybody didn't have all the computers on their desks. We looked at the teacher. And it's not just in class, it's outside of class. They're not engaged with each other, they're focused on whatever device is in their hand. And it goes back to childhood. And this is disturbing to me. Looks like a preschool classroom to me. But you know, technology is not all bad. It is good. I'm not saying that. And much of what I'm talking to you about, there's literature out there, and I have a bibliography at the end of my slides that there's a lot of writing on this. It's not my idea. It's just that you notice these things and then you read about them. And but technology is not bad. The problem in classrooms, as we know, is the distraction element. It's not just in classrooms. I'm sure some of you want to look at your phone right now. And it's okay. I don't mind. But for classrooms, we don't want our students doing that when they are supposed to be there learning and being engaged. And this is really the problem with young people using technology. I see it in my daughter. This is not her, but I'll be in trouble. But it's this lack of focus, boredom. You know, they find some things boring. And there's other problems that we find with technology. And I think, and from what I've read, and I'm not the psychologist and I'm not claiming to be the expert in this area, but it seems to cause distraction. It seems to cause superficial reading, because if you think about how we look at screens, and I've noticed it myself, if you're reading, we used to read the New York Times on Sunday morning with a cup of coffee cover to cover. Now, you can read it on your phone and click on a link. But by the time you click on one link and start reading the article, lo and behold, an ad pops up and, oh, those were the shoes I was looking at last night. Let me go look at that. Or you're reading the article and then there's another link to some other point in the article and you click on that. By the time you're done, you've never read the whole article you started to read. And that's the problem. Immediate answers. Right? Google and ask.com. If you don't know something, just go and get the answer right away. Forget who wrote it or what the source is, or vetting the source. You just need the answer right away. You need that information, and it has to be at your fingertips. informality, right? LOL and all that stuff. I don't even know half what it means. And disengagement from people because they're much more focused on what's going on. And again, that technology is not all bad, but these are some things that conflict with what we require of the legal profession, and we've heard some of this today. We need to be thinkers. Lawyers have to stop and think and reflect, not on themselves, just on themselves, but on our work, you know, and our cases and our facts and our clients. We have to read critically. Superficial reading's not enough, and we don't have answers. Most of the times we're not searching for answers, we're searching for law to support our argument and the positions we want to make for our clients. And we must be formal in our communication. And lastly, we must deal with people. So this is kind of the problem. So what do? I don't have all of the answers. I have a few suggestions for you today. So let's start with dialogue-based teaching. The term Socratic means different things to different people, and there are different levels of Socratic questioning, but it is a method of imparting information, not imparting information, but pulling information out of students. We know that engaged learning is better, right? Sitting and listening to a lecture is boring. You're going to lose the students, and they all have their laptops up, and you know, looking at them, that they are, and when they're smiling at the screen, they're not saying anything funny, you know what's going on there. But they can't help it, right? We do it too. We look at our phones too. But what about in teaching skills? I've been teaching this is my 6th year. So when I began teaching legal writing and trial advocacy, I prepared for a 90-minute class, and I would prepare a 15 to 20-minute lecture. Keep it short, and then the rest of the time, plenty of time to do exercises, to have discussion, to raise problems, right? But guess what? During the course of the semester, 15 to 20 minutes, and it wasn't every class, probably once a week, I was losing students. You know, I was sort of baffled by it. I tried to make my PowerPoints more interesting. I tried to tell stories. And I was baffled because I'm a former trial lawyer. I tried felony jury trials in Atlanta for 12 years. You know, I could talk to a jury for 2 hours and they'd listen to me. But I can't keep the attention of kids for 15 minutes, you know, in law school. But it's because over the course of the semester, lectures are a passive form of learning, and it's not useful. And I did not like losing my students even for a minute of class. I don't like it. I mean, it happens sometimes. So I found that I do my lectures in trial advocacy by questioning, and I do it in legal writing, and it makes the class much more interesting. And it's not the same Socratic method that you see in Kingsfield, of course, because the material is not quite the same. But when you ask questions, you get the dialogue, you take them down the path you want. I use my same lecture notes, I just ask questions now. It's so much more engaging. And then for those 15 to 20 minutes, everybody starts waking up and getting moving. And then we go into our exercises, kind of like a warm-up to do your exercises, whatever it is that you have planned for the rest of the class. And even in trial advocacy. So I'm a big proponent of dialogue, and I don't call it Socratic, because that term, as I said, means different things to different people. So my experience, this leads into oral exercises. My experience in legal writing. Students routinely comment that practicing their oral arguments, so we do similar to many people, predictive memo in the first semester, persuasive brief second semester, and then after the brief is turned in, we do oral arguments. So my students come and tell me after we have done the 3 weeks or so of oral argument practice rounds, working on it and then doing oral argument, they come to me, and for 5 years straight they have come to me and said, if I had done this oral argument practicing before I turned in my brief, it would have been so much better. Because all of a sudden they see the missing elements in their arguments, the leaps in logic that they made that were missteps, some things they could have done better or explained better in their paper because they have now orally articulated it. I also founded individual conferences with my students. This is after they have completed an assignment that I gave them, turned it in, I've given them comments, given it back, and now they come to see me and talk to me. So in a legal writing assignment, such as a memo or a brief, there's usually sections that I will mark globally, like this is insufficient analysis, conclusory, some of those kind of global comments that you can't quite, you mark it and try to give them more guidance, but how to fix it. But essentially what they're not doing is they're making the leaps from A to C without explaining how they got from A to C, and they're being conclusory. So I take one section of their paper, and I say, and I turn it over and I say, okay, well just tell me, what was your point with that case? And then we walk through it, and they're able to articulate it clearly. I say, well, that's great. Now let's look at what you wrote. And it has nothing to do with, it's a little bit of what came out of their mouth, but not as clear. And so then it's sort of stuck in, then they sort of figured it out. And then I said, well, wow, that's great. It's working. I'm doing these conferences. It's working. And then I tell my students in class, talk it out loud. With your cat or, at home in the couch. You can't get help with your legal writing papers, but maybe call your grandmother, and just have somebody on the phone listening to you to tell about your case and see if you can't talk out your analytical thought process. But they don't do it, so we have to sort of incorporate this into our classroom in legal writing. And that's one of the things that I've started to do more and more. I've learned also with teaching trial advocacy, can everybody read this? When they know they have to stand up in class before their peers and then to be critiqued by me, they are going to prepare. They read the problem, they prepare their questions, they type them up. Occasionally you have one or two that'll slack off and do it that morning, but most of them will work on this. Particularly for my final trials, you would not believe the transformation from the beginning to the end and how they come out so professionally. I have never had a trial out of class where at the final trial they just were all sharp, no matter where they started at the beginning of the semester. It's probably because I'm grading them, of course. It's a big chunk of the grade, but that helps. But they learn to differentiate facts from conclusions, which is not that easy to do when you have a fact pattern given to you and you're just reading it. In trial advocacy, when you question a witness on cross-examination, if you ask that witness a conclusion question, they won't answer it, or they will give you a hard time, or they run off at the mouth, and then you can't control them. So they have to be very, very specific, and I give them examples, and by doing it, they learn to differentiate facts from conclusions, which is a very important skill. And they have to learn in closing arguments how to explain to the jury. The jury has to apply the law to the facts. They have to go over the jury instructions, which is the law, and the facts of the case that they heard, and explain to the jury, so that they have to learn to explain that to someone else. They have to know how to do it. So these are lessons that I've learned from my experiences with legal writing and trial advocacy, and it was reinforced at the SEALS conference recently. I felt so validated because I had this theory that, speaking seems to be helping my students, and I want them to do it more. And so there's this great presentation at SEALS where they talked about they talked a lot about the Bloom's taxonomy and active learning, engaged learning, a lot of different things. But one of the things they mentioned was that increasing activity level in the classroom, doing something, either writing exercises certainly help, but vocalizing. The think aloud method, they mentioned it, and I went and Googled it, of course, because I need the answer immediately. But think aloud is this method where children in elementary schools doing math problems, the written math problems, like Susie sells newspapers and makes 25 cents profit, how much, et cetera, et cetera, et cetera, how much profit is she going to make? Instead of students just thinking and then doing the problem, they think, they vocalize how they're going to analyze it, and then they do the problem, and it has been studied, and they say it's helping the students better their analytical skills in math. This is what the science is saying, that articulation out loud helps your analytical skills. And which is why I'm advocating more oral activity in our classrooms. The other point I want to make today is the importance of advocacy. Advocacy in law is not synonymous with trial advocacy, which is what everybody thinks. Oh, I'm not interested in advocacy, I'm not going to be a trial lawyer, I don't want to present cases. But advocacy really is a general, it's everything we do. It is the legal profession. You advocate when you're representing the client at a mediation, when you're negotiating their case, when you're preparing discovery and depositions. You're advocating, the client is at the forefront. Right? We certainly have all of the other ethical obligations, but as lawyers, we work for our client. Whether you're a government, in government or private practice, even prosecutors, they don't necessarily have a physical client, but they represent an entity, which is the state. And why not introduce the client to our students earlier? Because one of the other things about learning in the classroom to improve skills, you need motivation, you need interest, you need engagement, and you need to be working with others. So, and having a client introduced to the student and putting them in a position of an advocate helps them to be motivated. Advocacy, the other part about advocacy is that there's this general conception that we have to teach them how to be objective and see both sides before you can advocate and take a position. And I personally disagree with that. Because if you think about the art of war, which is principles I use when I teach trial advocacy, is that to be a good advocate, you have to know the other side. You can't possibly create an offense unless you know what the defense is going to do. And so I don't think that necessarily, and the only time that lawyers function in this objective role is if they are the judge or they are the mediator and they are trained to be in that role. Then if you're not the referee, you're a player, and you're going to have to you're going to have to play the game. You're going to have to see the other side. So I don't necessarily think that it's important to teach someone how to be a referee first and then learn to take a side. I don't think that that's important. I think that we can have our students take sides. So some of the drills that I use. And they're easy. Most of my drills are very easy. You can do them on the spur of the moment. You don't have to actually have them prepared. Have students line up in pairs for parties. And you can do this even on a memorandum type assignment. Basically, you can have them make arguments, or you can have them just make their point. We're trying to get them to make a point and then back up their point. So if you can have them line up, and again, activity level increases participation, increases their comprehension, make them get out of their seats. They hate it at first, but then as they get used to you doing that, they enjoy it. So have them get up out of their seats. They can line up in 2 lines, or you can do it like the speed dating. Have them sit on one side, and the other people come through and make a point about the assignment. Whatever the point is. The point being the thesis statement, or the point of using a case, the argument that they're going to make, whatever your assignment is. Have them make that argument and back it up and see if the person sitting across them can respond, or have the person sitting across them play the judge. You can do this in groups. Again, group work is good for engagement. You have them groups of opposing parties and make arguments to each other. And you can have a group of students play the judges. And they can be the judges for who wins. And then you can have prizes, you know, a candy bar or, you know, something very small. And it motivates the students, gets them out of their seat, again, and have them do teamwork. First to the finish line, have two people on either end of the room. This is the imaginary line, so they make a point. If it's a credible, and have judges again, if it's a credible, a credible point that's convincing, and it can withstand a counterpoint, let them take a step forward. And then you have a game going. You have all of the students engaged in what's going on. Another drill that's similar to, and I'm a big proponent of having students play different roles. They should learn to be judging, you know, meaning play the role of the judges and evaluate their peers. When I do trial advocacy, and I was criticized one time by a professor who came and watched me, because in trial advocacy, I start out playing the, you know, being the judge, but then sometimes I play the witness, because that's when, you know, that they're cross-examining me. I know the fact pattern better than anybody, and I can give them a hard time. And sometimes I'm in the jury box, and when I'm in the witness stand, when I'm in the witness stand or in the jury box or playing opposing counsel, I take volunteers who wants to be the judge, and then the judge has to rule on evidentiary objections, and so we have, you know, a free-for-all objections throughout the semester. So no matter what anybody is doing, anybody in the room can make an objection. So it's that kind of engagement that you can take some of those principles, some of those lessons from trial advocacy and incorporate them in a writing class to get people to vocalize more. And especially for those students who sit behind their computers and who are shy to speak or who don't have the confidence, sometimes when they start talking, it's amazing that their confidence throughout the semester starts to build, and then they become more comfortable with their peers in this environment. This is similar to, I think, one of your exercises, the minute drill. You know, pick the issue that you're having them write on, and what I do is, if they're doing a research assignment and they're writing for me in our class, I just say, don't talk about cases, the case names, but the principles of law, and how does, and explain a few facts and tell me how it applies, and do it in a short frame of time. You can say 1 minute, reduce it down, reduce it down. What this does is help them to come up with those thesis statements or premise sentences. If they have very little time to think, and if you put them in groups to come up with those thesis statements again and have a prize, they work really fast. I do that again in trial advocacy with, write your case theory on a notepad. Now tear that in half, do it in half a page. Now do it on a Post-it. And you can do the same thing in legal, in writing classes to get them to drill down to what is actually most important. The other way, what I talked about, introducing the client into our curriculum earlier. So we tend to give them an entire set of facts that they have to analyze. But what if you gave them fewer facts and left out some facts of the fact pattern? It's an easy thing to do. You take a problem that you have, take out a few facts, and let the students then come up with the questions that they would ask the client, and let them conduct a client interview. And again, you can play the client and let them ask you questions, and you can put them in groups of teams and let them do it individually, so 3 people at a time come and interview the client to get them to come up with the facts. You can do that in the context also of discovery, and I think some of you may be doing that already if you have pretrial advocacy courses, but that's what you need to do, is teach them how to figure out what additional facts do I need to solve the legal problem. And then this exercise, which I loved, came from one of the professors I work with at John Marshall, Jeffrey Vendetta. If you don't know him, he's wonderful. and brilliant. And he had an employment discrimination law seminar class. And what he had his students do was prepare a presentation, at the end of the semester, prepare a presentation to the client, explaining the outcome of an issue. And it was, the client was a small business owner who had a potential discrimination, what was it? I'm not that familiar, I can't even remember exactly, but it was a Title VII, but there were some other facts to it. Potential Title VII action against her small business, where she only had she only had 2 employees, but she had a number of contractors, independent contractors that worked for her. Somehow she qualified under what Title VII to be considered an employer that had to abide by the regulations. And so he had the students get in groups to be a small law firm and prepare a presentation. And I assisted Professor Vendetta by playing the client. And I was kind of, I played the typical client, and I was a little bit clueless about the law anyway, so it was easy for me to come in there and, press the students, why should I hire your firm? And what the students got was, suddenly, there's this person here, and I can't just talk down to them or cut them off. This is the client. Because I was asking questions, and some of the students cut me off, and I said, well, I'm not going to hire you. I want a lawyer who listens to me. I'm the boss here, right? So they kind of learned that, and I thought that was a brilliant exercise. Like, well, we could do that with our predictive memos and put them in teams again. Turn the predictive memo and put them in a team and make them do a client presentation. It really helps them understand real-world application of what they're doing. So, in closing, what we need to do as teachers is, to understand our students, create contextual environments, engage them in the classroom as much as possible. And again, one of the things that they talked about not just at the SEALS conference that I attended, but in literature is the Bloom's taxonomy, right? That there are levels of learning, and we want to get to that higher level of learning. Remembering and understanding is just the baseline. We want to get to even applying and analyzing. Is that they have a pyramid. Bloom's taxonomy is at the middle of the pyramid. The top of the pyramid is creativity. So we want, and I think this pressure to create practice-ready lawyers is a pressure on us as teachers to not just impart information, but to get the students in class to try to get to that higher level of learning, which is creation. That's why flipped classrooms are being tested now in legal education. And that's why we need to incorporate some of these other ideas. And my suggestion is to put them give them a side, make them advocate, and make them work in groups, and make them vocalize what they're thinking. And I'm hoping that will help. So thank you very much.
Thank you.
A long list of articles I read, and these are the professors who presented it. If anybody wants it, I'm happy to email this.
Remarks for everybody. I hope you're inspired and happy and ready to go out and change the world, or maybe take a nap. I don't know. So we started off today with Judge Coleman, and she kind of gave us kind of what I think ended up being our theme all day, was law to life, right? And so the practitioners brought in life, skills, and the demands in the marketplace, and brought with them their concerns and some suggestions for us on how to remodel our curricula. And we went back to law with Professors Pleasant and Shepard and how to integrate life lawyer skills throughout the curriculum, and how our colleagues were doing that and how we could more effectively do that. Lunch brought sustenance and a shift in focus with professional identity with Dean Floyd and Professor Longin. And we continued these themes with Professor Mullins and Kelly, and ended with innovative classroom practices to aid in learning transfer from Professor Malempati, and got a better sense of our challenges going forward with our student population with Professor Webb. So we thank you all for coming to the heart of Georgia to help us make it and practice ready lawyers. And I want Sue to come up here because she hates all kinds of public stuff, so I'm gonna
That's why you want
make her
to
come up here.
I hate it.
You're gonna
That seems perverse.
I'm
in a
gonna
way.
make Sue come up here. And so Sue here has been tireless in working to make you all have a very nice day, a very productive day. And she kind of, you know, she's not gonna like this analogy, but she loves animals, so she might. But she's like the mama duck, and you know, she kind of gives us our charge, and we all kind of.
Can I just be the border?
Okay, you'll be a border collie. And she rounds everyone up, and she tells us what to do, and we do it. But no, seriously, she has been an anchor in this, and so without her, none of this would be possible. And so please give her a just round.
To share the love back, I would like to say that Jen Shepard and Karen Sneddon came up with the program and the structure for today, and you did, I think, an excellent job, and I'm so glad you all were able to join us, and I love the presentations. And Carrie was our point person on PR and contacting everyone and getting the word out about us. So it was very much a group effort.
Teamwork makes the dream work, people. And I'm full of them. I got a million of them. Last thing I want to say is that we have tremendous colleagues here at Mercer, and this is the reason why we're able to do this, because we all, one thing I love about my colleagues, especially my legal writing colleagues, is that we really don't have egos, and so we just kind of do what we're told, what each other tells us to do. We're like, do that. Okay, we'll do it. And so that's how we're able to do this. So I hope you all had a wonderful time. I know that I enjoyed spending this day with you. And if you're still in Macon tonight, you're looking for some place to eat, in your package, you have one of our wonderful colleagues, Dick Presswell, has put together a list of restaurants in Macon called Dick's Picks, which he hands out to the first year students. And he actually has reviews on where to go and what to eat, and he's usually pretty spot on, so I would listen to Dick.
Thank you.